asked me, would you come and do this webinar? And he said, Vivek said you should do it. I said, well, you can never say no to Vivek. I mean, Vivek has this persona.
So kind of you, Anupal.
Vivek has this persona which has carried him very well in the Supreme Court, and a level of respect which all of us have for him. And that was frankly the only reason why I said yes, apart from obviously getting an opportunity to be able to talk to you and share with you some of my experiences. Now, what I haven't told Vivek, and I must tell you, I must confess, I had a little chat with him 10 minutes ago about how we would go ahead with this. And Vivek will front load most of this seminar, because what I did not tell Vivek is that I would pretty much have to log off in 10 minutes because I have a hearing starting at about 5:20. It was starting at 5. I've deferred that so that I can address you all for at least 10 or 15 minutes. And you will be in the very capable hands of Vivek. And I can tell you that what he will tell you is pretty much what I would have anyway told you. Let me just break this topic into two broad heads. And I think if people could put, if everybody could be on mute, it would be useful, because I think I'm getting a lot of background noise. Yes, thank you. Sorry, if there's still a lot of background noise, it would be just better for people to put themselves on mute.
Himanshu, can you please mute everyone?
Yes. So if you can hear me, great. So let me just break this topic up into two broad heads. When you talk about arbitration and mediation, you have to look at it from how it would be in the ideal world, and B, how it is in the real world. Now, in the ideal world, what's the best thing that can happen? Parties don't want to have disputes. Okay, but that's not the real world. Okay, in the real world, parties have disputes. But if you had an ideal world there, they would resolve the disputes amongst themselves. Again, in the real world, that doesn't happen. And when disputes arise between parties, and when you're looking at arbitration and mediation, you're typically looking more at the commercial world here. You have two forms of dispute resolution. One form, which is a conciliatory form, and that is mediation. And then you've got the second form, which can be broken down into two subforms, which is the acrimonious form, and that is arbitration or litigation. Now, what is so exceptionally good about or great about arbitration? Well, honestly, nothing. And I'll tell you why I say so. Arbitration is nothing else but an acrimonious method of resolving disputes in a private forum. It's just that parties choose to do it that way. But the way you go about an arbitration and the procedures you follow for an arbitration are pretty similar to the procedures you would follow for a litigation. You will file a statement of claim, you will have a statement of defense, you will have evidence, you will have cross-examination, all of which at the end of the day leads you to a position where a third party will decide whether or not you are right or you're wrong. By the end of the day, one party is going to be left unhappy with the decision that is made. And now when you look at that and you compare that with mediation, which is a method of resolving disputes that is not acrimonious, where both parties are entitled to present their case and present their position, and the mediator, who is a third party who is neutral to everybody, looks at finding a solution which is practical, which is commonsensical, you end up in a position where both parties turn out to walk away from that mediation in a scenario that is a happy state of affairs. Now, the question is this. I mean, all of this sounds very good when you do it on paper. In the real world, unfortunately, it doesn't happen as easily as you want it to. I mean, you would have thought that in the commercial world, people would be practical. They would think about their money. They would think about the amount of expenditure they have and would try and come to a quick, fast-paced solution. Well, the reality is very different. The reality is that people, for reasons which are very impractical, continue to love to fight. Very often, it is corporate egos which come in the way, and that make sure that parties do not resolve their problems. And very often, somebody doesn't want to take the blame for something that's gone wrong and would rather fight it all the way through. And at the end of the day, have a third party make that decision. So what happens in the real world is that if you get into a scenario which involves an arbitration, you literally have to take a number of steps, which involves putting a significant amount of commercial pressure for somebody to come in and say, let's come and try and mediate this so that we can arrive at a faster solution. How is that done? Well, I can tell you honestly, it's not done by just raising an inflated claim. Okay? It's not done that way. It is done by raising a good claim, a claim on the basis of which a party says, well, if I lose this case and I lose this in 1 year, what's going to be the end result? So let's just take a simple example. I have 100 crore claim and I decide to raise 100 crore claim and I raise it on good credible grounds. And the other party says, well, within 12 months, I will lose this claim because I know I don't have a good case. Here is a possibility of mediating it and settling it at 80 crores or 60 crores. I save a lot of money. Let me try and go in for mediation. Okay, and it's very possible that the party is going to go ahead and do it. On the other hand, if you take 100 crore claim and inflate it to 1,000 crores, there is reasonably going to be no possibility of mediation being successful because nobody is going to mediate a 1,000 crore claim when they know that it's not a genuine case. And that's an extremely important aspect that parties who are initiating a dispute need to consider. The other aspect which parties who are initiating a dispute need to consider is the reality, and this is from a claimant's perspective, the reality of being able to see the money. I might want to raise 100 crore claim, but what is the chances of success, even if it's an exceptionally good case? It is, at the end of the day, a decision which is going to be made by a third party. And multiple things can happen through the course of the proceedings, which may derail that 100 crore case. So in such a scenario, again, mediation becomes a very viable option because, as you've all heard the adage, a bird in hand is better than two in the bush. And that's a very sensible approach which parties often take when they look at arbitration or mediation. Now, it is based on this commonsensical approach, which, as I've told you many times, doesn't exist, unfortunately, in the corporate litigation world. But it's based on this commonsensical approach that you have the Arbitration Act and you have the conciliation section in the Arbitration Act. It is effectively meant to allow for dispute resolution to happen at an expedited pace in a manner that both parties can walk away and close their disputes. I'm going to take a step ahead from the Arbitration and Conciliation Act because I'm sure Vivek will deal with it in more detail. And Vivek has promised and told me that he is going to deal with some very significant decisions of the Supreme Court during this talk. But let me move into something which is slightly different. When you look at the Arbitration and Conciliation Act, you see these two parts of the statute in two separate compartments. What the international arbitration world is moving towards is a procedure called Arb-Med-Arb. And that is extremely important for everybody to consider because if you're looking at the future, that is the way to go. You initiate an arbitration because you start everything acrimoniously. But then if somebody tells you that there is a procedure where you're required to sit down and negotiate your case, to try and work out a mediated settlement, both parties pretty much know after the pleadings are complete, and perhaps at some point the evidence statements have been drawn in, where they stand. And once they know where they stand, they can take a more sensible call in trying to mediate a dispute. So it's not a case where a claimant at every stage will say, I've got 100 crore claim, I must get 100 crores. Or a defendant who says, I've got 100 crore claim, but I will pay zero. And that is where the Med-Arb-Med procedure becomes extremely important. And in my view, it is important for people in India to try and move towards Arb-Med-Arb for the simple reason that given the number of disputes that are going on, we need to find a commercial way and a practical way of ensuring that we have quicker disposals at a significantly lower cost. On that note, I'm pretty much going to end off and I'm going to let Vivek take over. But let me leave you with one thought. Don't ever think that culmination of a dispute means that lawyers will have less work and that you should not encourage the closure of a dispute. What you need to consider is acquiring new skills. Let me tell you, some very successful practitioners are trained mediators. So if you cannot do it in a court because people are moving away from courts, and you cannot do it in an arbitration, well, you can also acquire the skill of becoming a skillful mediator. And I can guarantee that you will be exceptionally busy. But thank you again very much for inviting me for this talk. I'm sorry I have to leave because like I told Himanshu earlier this morning, a hearing has come up, so I need to leave you to Vivek, and he will definitely tell you significantly more about the topic today, including on some Supreme Court judgments, which are extremely relevant. So thank you very much. Say, Vivek, you're on mute.
Hello. Sir has already left, but he had to leave for some work urgency. We apologize to everyone. I would like to invite Vivek Narayan Sharma sir to take over the session. Uh, Dr. Advocate Vivek Narayan Sharma sir is practicing as an advocate on record at Supreme Court of India. Sir has also played a significant role as an ex-joint secretary of Supreme Court, AOR Association. He has been awarded as Star Advocate on Record by Business World magazine in December 2019. There are many other number of recognitions added as feather to his cap. I welcome you, sir, and I request you to begin with the second half of the session. Over to you, Vivek, sir. Himanshu, sir, you have to unmute him. Give us a second, sir. Yes, sir. Over to you, sir.
Thank you, Devansh, and thank you, Himanshu. And it was nice to hear Nakul, due to urgency and due to a matter he was doing, he had to leave. I think he has already left. So it is a nice interaction that has started on a very good note. He talked about certain things as to how the corporate deal with these issues, adversarial, non-adversarial. So essentially, when we talk about arbitration and mediation, today's topic is arbitration and mediation. Forging our thought into certain aspects of adversarial and non-adversarial. Essentially, it is said that arbitration and mediations are non-adversarial processes. But as Nakul said, I also agree with him. More or less, arbitration process has been involved into evolved into an adversarial process in so many ways in today's time. Because ultimately, if you look at it, the entire court process as it takes place, leading evidence, filing of documents, filing of a statement of claim and a statement of defense. So many things are there, and which already takes place in the form of suit, WS. The only difference is the tenure. And then you have a personalized vehicle, like courts are those taxis or buses. It means if I have to compare. So courts are those places where a person is traveling in a general compartment, and your case is means dependent on the outcome of certain eventualities, like whether how many matters are listed in one court, how many matters will be heard by the judge, and how many matters will he be able to decide or hear or really lead the evidence, and all those things. So in arbitration, essentially what happens, it is a private court hearing, court proceeding, though it is, we say it is arbitration proceeding, but it is a private dispute resolution proceeding in which you have time and you have this under the closed um, area, you can decide on the issue in a fast-paced manner. And even then, even in arbitrations, there used to be means a lot of time taken in deciding those issues because of the nature of the disputes, which are commercial, technical, engineering based issue. So in such a scenario, what used to happen, it used to take a lot of time. So therefore we saw 2015 Amendment Act that came, which prescribed a limitation with regard to the providing the confinement of that period, that the arbitration should be decided within 1 year period. Then we have seen the amendment in 2019 also. So while these amendments had been relevant to make the tenure of the arbitration much less, so there had been so many things. Now the new Arbitration Act has come, and then making substantive changes. So I'm just outlining. Means anybody was speaking something, I suppose?
No, sir. No, sir.
Okay.
Actually,
so I'm just putting an outline into the effect that this is how we have been traveling into it, the terrain of arbitration and mediation. So mediation is not the word which occurs in the Arbitration and Conciliation Act. So there is the word used is conciliation. So what is mediation? What is conciliation? So there has to be some difference between mediation and conciliation, because essentially what happens, mediation happens under CPC, and this is in India usually the scene is that mediation happens post litigation. Conciliation happens pre-litigation. So if we have to understand what is the means, I will start my process, my lecture on mediation by telling you the difference between mediation and conciliation. But before that, understand that there are 4 types of litigation. I mean, 4 types of communication that happen between 2 disputing parties. To start with, that is the meeting, that is negotiation, meeting of parties. That's the first part. So at times parties propose with each other that let's meet and iron out the disputes that have occurred between us. So in so many times, occasions, and especially in business environment, it so happens, and also in family environment, it so happens that meeting takes place. Once the meetings fail, and then there is no dispute resolution found in those meetings, mutual meetings, which are called essentially in legal language, it is called negotiation. So if through that negotiation no result has arrived at, then in that case parties may refer to mediation. So mediation means it may be self-appointed mediation, that you appoint some person of a social repute or somebody from a very senior from your own family to decide on the issue, or means in the corporate sector, maybe some third company, some entity, some CEO of some business occurrence may decide may intervene the issue. However, if we look at the mediation and conciliation from this perspective, so though both are alternative part of the alternative dispute resolution, but at the same time, here in mediation, the third party that we appoint acts only as a facilitator. However, if we find this in conciliation, Arbitration and Conciliation Act 1996 contain, chapter 3 of that act contain the provision of conciliation as to how the conciliation has to take place. Mediation is provided in section 89 of CPC. If suppose there is post litigation mediation that may take place, so that can contain the force under section 89. And conciliation will come under Arbitration and Conciliation Act 1996. So chapter 3, if I was talking about the difference between these 2 terms. So facilitator, mediator acts as a facilitator. On the contrary, conciliator acts not only as a facilitator, he is a domain specialist of that particular subject. And then he can work as an intervener. He would be a specialist of that subject matter. So therefore, he will iron out the issues and give the plausible solutions, provide the parties the plausible solutions, the possible solutions that may come into effect. And then the parties have the chance to choose one among those solutions. On the contrary, in mediation process, what happens? A mediator can act only as a resolution, means only towards resolution by way of bringing the party to a consensual level. He is not a subject matter expert. Only he is a means mediation expert, conciliation would mean this conciliator would have essentially a background on that subject domain, and then he can really pass a conciliatory order which can work, means which can be executed just like an arbitral award. However, on the contrary, with regard to the agreements, mediation, when the parties arrive at an agreement, so it is enforceable as a law in law, but at the same time, this will not have the force of an award, or this will not have a force of a decree. In a conciliation proceeding, this would have a force of a decree. So, before delving further in this direction, I would take the friends to the certain provisions of Conciliation Act. So Conciliation Act, it starts at the Arbitration and Conciliation Act provides sections chapter 3 onwards. We look at the conciliation factors, where section 62, where the written and invitation and acceptance is a requirement under the law. So if you want to initiate a conciliation, then the party has to initiate by way of writing to the other party, invite him for conciliation, and if the other party accept, only then in that case the conciliation proceedings may start, and then they can agree on one conciliator or two conciliators or three conciliators. And here, unlike arbitration proceedings, in arbitration proceedings, it has to be always an odd number. However, in conciliation proceedings, it is not a requirement. So in conciliation proceeding, it can be one conciliator, there can be two conciliators, or there can be three conciliators, depending on the need of the parties, depending on the nature of the dispute, depending on how the issue has evolved and how many expert people would require to really resolve it, and depending on paying capacity of the parties as well. So once the dispute, once the appointment has been made, then there is a submission, just like as arbitration proceeding. In this case also, there is a submission of certain documents, but not like the same as it happens in arbitration. In arbitration, the statement of defense contains the entire flow of the facts, at the same time the nature of dispute, and then the supporting documents, and all those things which are relevant for the purposes of evidence to bring out an award. On the contrary, in the conciliation, as per section 65, the requirement is only about giving a brief synopsis, giving a brief facts statement to the conciliator or conciliators would be suffice in this case. So if after that period, the conciliator may feel that there is some supporting documents required, so then in that case, those documents can be provided, and then the conciliator may see. The essential difference that comes here, if we compare it with the mediation, I mean tangibly comparing those proceedings on the parallel scale. So if we look at the mediation, in mediation there is no exchange of documents usually. If we look at the post-litigation mediation, where the court-appointed mediation takes place under section 89, I'm not talking about pre-litigation mediation as of now, because means when I would talk about the mediation in the later part of the session, we will talk in detail about mediation, pre-court mediation and post-court mediation. So right now we are just understanding what happens in these different proceedings, because we are talking about the procedural part. So when in mediation, in court-appointed mediation, because the files are already there, the matter has been referred from the court to the mediator. So mediator is not sent the files at all. Mediator is sent a office report mediator is sent a submission and the parties' details, and parties go and meet the mediator, explain the situation to the mediator, and therefore the mediator comes to understand, okay, these are the issue. Then mediator tries to individually talk to the parties at dispute, and then jointly then thereafter the mediator start talking them jointly. So this process keeps on revolving. Sometimes individual talks, sometimes joint talks. So this is what happens in the mediation proceedings. However, in conciliation proceedings, once the facts have been granted, given in the statement of fact, and in a very concise manner, unlike arbitration where you have to file a claim, then in that case, if the conciliator is in requirement of certain facts, evidence, documents, that conciliator can ask those documents and can ask the party or any party from which these documents can be procured. Another very important and very interesting fact that is there, when the party has been asked for providing documents, in arbitration and in mediation, the confidentiality of documents is based. In arbitration, there is no confidentiality of the documents because all documents are exhibited. In mediation, the confidentiality of document can be provided subject to the whims and fancies or trust factor of the mediator. Here, there is an embargo under Section 70 of Arbitration and Conciliation Act. Embargo is that once a conciliator has been told that this document is of confidential nature and the party does not want to share that confidentiality with the other party, then in that case the conciliator is under the obligation to hold that document in privacy and not disclose that document with the other party till the time that party whose document of this document belongs allows him to open that document to the other party. So that is specific provision with regard to confidentiality. So if we look at this from the perspective, if suppose there are certain kinds of dispute in which certain confidentiality is required, pre-court, if you want to settle this kind of matter, then what is the right forum for you? And what is the right forum if your client asks? Then the right forum would not be the mediation. Without going into adversarial litigation, without going into the detailed cost of, in a the time delaying litigation, when you have to go for mediation or conciliation, then conciliation is the right answer to such a party. If you have to answer that there are certain confidentiality, you don't want to share that confidentiality with the other party, then in that case the party should be advised to go for the conciliation. So this assumes very important significance in that area. If you have certain corporate clients, you have certain clients and they want to initiate a non-adversarial process with another party, and in that case you can definitely advise that of your client to start conciliation instead of mediation or arbitration. So that's one part, and as I told you already, under section 73, 74, this agreement is enforceable under law, just like arbitral award and just like a decree of the court. So this is what not happens in the mediation proceeding. Under mediation, if it is a court appointed court in mediation, then in that case it is only having a force. It is enforceable by law, but ultimately you will have to invoke law to seek its enforceability. Being a decree, it is deemed that it is now enforceable. It is enforced that you have to just execute the decree. So this is the difference between the mediation and conciliation that I just wanted to point out. So if we look at the recent phenomena, means all of you must be aware that Supreme Court has been very active in the recent time, and lot of judgments have been passed in last 2 years with regard to arbitration matters. And at the same time, there have been certain changes into the ambit and into the readings after the coming of the certain changes in the 2019 Act in arbitration law. So there must have been you must be curious how the Supreme Court is treating this particular subject today. In a very recent judgment, which was passed in 2020 only, where Supreme Court, an issue came under our Section 7 of Arbitration Act before Supreme Court, where arbitration clause providing for arbitration of claims of one of the party and providing for the remedy of the court or any other forum for the claims of the other party. So the Supreme Court held in this matter that the use of words all or certain disputes in Section 7 of the Act permit classification of disputes but do not permit classification of claims. So if in this matter what had happened, the arbitration clause was so designed that one party can seek claim under Arbitration Act and the other party was barred from claiming under the Arbitration Act. So referring to Section 7 of the Arbitration Act, Supreme Court came to the conclusion, this is a judgment which came just before the lockdown period. So that's why I just mentioned it. In the first week of March, this judgment came. So Supreme Court referred and Supreme Court said that there can be classification of disputes. I can understand, okay, such and such dispute has to be referred to arbitration. But there is no classification provided under the Act of the claims that such and such party can claim, but the other party cannot claim. So both the parties or all the parties involved in an agreement have the equal rights to claim if any disputes per se arises out of that agreement. So that becomes sometimes in the arbitration, sometimes such a thing happens. In another matter, Supreme Court held that a person who has an interest in the outcome of the decision or the dispute must not have the power to appoint a sole arbitrator. You know the significance of this particular decision by Supreme Court. This came last year, somewhere late November, December. If you are aware that all the PSUs, public sector undertakings, this is a very vast effect on the functioning of public sector undertakings. Because what happens in PSUs and all the big companies, corporates, they have a usual clause with their contractors. They have a usual clause of arbitration with their contractors and even builders, with the home buyers, that they will appoint an arbitrator, and the arbitrator would be their engineer, their chief engineer, or somebody from their company. Prior to this period, this period, the position was in so many arbitrations, the arbitrations used to be decided by the people who were part of the company, mostly PSU, but at the same time, those dominant corporations which are serving to the public at large, but at the same time that public is so small a fraction of their entity. So therefore they had the control over the agreement. It is a unilateral agreement which was provided to the public. So many times this kind of agreement was challenged before Competition Commissions of India also in different matters. But now Supreme Court has nailed this particular area by saying that a person who has an interest in the outcome or decision of the disputes must not have the power to appoint a sole arbitrator. Legal person is, if we have to understand person, then person has to be a legal person, a company, corporate, an entity. So now after this judgment, if a company, a corporation or PSU appoints a arbitrator, their own civil engineer, their own officer as sole arbitrator to decide a dispute between them and their consumer, then in that case, this cannot be done because it is going to affect them. It is their interest. So that to block that interest, Supreme Court has passed this wonderful judgment. And you must, means I'm not citing the citation. If you need, it means this is Perkins Eastman architect matter, which was decided in 2009, November 2019. So in another matter, I would just like to, means I'm just mentioning few judgments, and then post that we will start something else. So with regard to the designation of seat, so this was a judgment in Soma versus NHPC. So with regard to designation of seat, Supreme Court held that designation of a seat confers exclusive jurisdiction on the courts of said seat, and a place of arbitration, regardless of its designation as a seat, venue or place, is the judicial seat of arbitration unless there is an indication to the contrary. If you must have known that with regard to arbitration, designation of seat or seat of arbitration, place of arbitration has always been in contention. Why so? Because when the arbitration takes place, as per the agreement provides for the place of arbitration. When it provides for place of arbitration, then that place of arbitration, as per the agreement, that becomes the seat of arbitration. In conventional way, if we look at the later part when the arbitration has started, so the agreement contains, suppose, New Delhi as a place of arbitration, so that becomes a seat of arbitration. For example, their NHPC is situated in Faridabad. Another party is situated in Delhi. NHPC said all the arbitration will take place in Faridabad. So as per that agreement, the seat of arbitration becomes Faridabad. So if anything happens to the contrary to the agreement, any dispute arises, then where the arbitration will take place? As per the place of arbitration, which is in fact the seat of arbitration provided in the agreement, contained in the agreement. So the place of seat of arbitration would be Faridabad. But supposing when the arbitrators have been appointed and both the parties consented that the arbitration will take place in New Delhi, then what happens? So that now means this has been always a conflicting jurisdiction, means conflicting territory, for the reason because sometimes NHPC may feel that the Delhi High Court would give it relief, or sometimes they will feel the district judge of Faridabad may give them relief. So as per their convenience, they may accordingly align and design their own definition, and the private party may also do the same. So there has been, with regard to seat and place of arbitration, there have been always certain disputes between parties as to what should be the seat and what should be the place of arbitration. There had been several judgments in this regard, and very simply speaking, to make you understand on this particular aspect, the seat of arbitration is different from place of arbitration. The agreement clause which contains it is actually, maybe it is designed as place of arbitration shall be New Delhi or place of arbitration shall be Faridabad. But actually it is the seat of arbitration it is talking about. When the arbitration agreement is talking, so that is the seat of arbitration. So seat of arbitration is as per the agreement. But the arbitrators may define, all right, we will sit in Delhi. So here there are two-fold submissions. One is that the parties may agree that they will shift the place of arbitration to Delhi. And if they have not agreed to that fact that they will change the place of arbitration from Faridabad to Delhi, then in that case the seat shall always be Faridabad, but the arbitration can take place in Delhi. So that would be venue of arbitration as compared to the seat of arbitration. So these two things will become two different places. So it so happens at so many times, even in international arbitrations, that the seat has been provided in Singapore, and for the convenience of the party, one hearing, two hearings, or evidence takes place in New Delhi, or in Mumbai, or maybe London. So the place of arbitration can at times, or the venue of arbitration can at times be transitionary interval, transitionary position. But the seat would be as per the agreement that is provided under the Act, unless the parties have agreed to a new seat by way of their own consent. So in another matter, and this has been again very recent, in February 2020, Supreme Court held that when a lease deed or any other instrument is relied upon as containing the arbitration agreement. So I will ask, means if I had there been an audience live with me, then I would have asked them the question right now. If there is a document which is unregistered, on the basis of that, if the arbitration clause has been invoked, then what happens to arbitration clause? Can it be effective? Can it be enforced? Ordinarily, an arbitration clause, even those agreements which are not legally valid, the arbitration clause remains valid. But here Supreme Court has held very differently. The Supreme Court said when a lease deed or any other instrument is relied upon as containing the arbitration agreement, the court is required to consider at the outset whether the document is properly stamped or not. If the instrument is not properly stamped, it should be impounded, and the court cannot act upon such a document or the arbitration clause therein. So if it is a document which is required to be registrable under the Registration Act and it is not registered, then such a document, the fate of such a document under Section 8 of the Registration Act becomes impounding. So in this case, Supreme Court said that in such a matter where arbitration clause has been contained, but at the same time the document, though registrable under the Registration Act, was not registered, then in that case the arbitration agreement cannot be acted upon. So there have been so many other matters which the Supreme Court had dealt in with, and so many judgments passed in recent times. So we come to the periphery of Arbitration Act, but prior to that, means I have already talked about certain judgments highlighting how the Supreme Court has dealt in with. I wanted to talk about, before we go further into arbitration, there is another aspect that I wanted to talk about with regard to mediation. How many of you are aware that India does not have the Mediation Act? Means we do not have any pre-litigation mediation. We have only Section 89, post-litigation mediation. Rest all is informal mediation. There are certain mediation institutions which are running. These are private mediation institutions. Then there are court annexed mediations, like Supreme Court has a mediation center, Delhi High Court has a mediation center. Tisazari Court, different courts have mediation centers inter se to support the party when the litigation is going between them or among them. And in that case, they said the parties are sent. Usually these are in what kind of matters usually the mediations occur. These are mostly family matters and the husband-wife disputes. But if we look at the potential of commercial matters, the potential of, means now the government is thinking of overhauling the Section 138 of NIE Act, Negotiable Instrument Act 2. So if you look at those commercial disputes which are coming, and the nature of those commercial disputes, means the litigation which is pending and that kind of nature, means they may be petty, they may be means intermediate disputes, and then there are some commercial disputes, means more than 2 crore of value. We look at the influx of those kind of matter is very high. Apart from regular criminal matters, if we look at that, mostly even criminal matters, if we look at the data, these are the commercial disputes. 138 matters, they are in large number. Commercial means because of this Section 138 matters, if we take out that particular matter out of the court ambit, then at least 60% litigation in criminal courts will go down. It is of that volume. So government has not been able to think it this way prior to. unless means recently the Supreme Court appointed a committee a few months back for formulating the legislation for mediation, and it would be very interesting for you to know and for you to prepare for the future. As Nakul had already said, that means what can be means really very great for the lawyers or the upcoming lawyers, that they should always endeavor and try to be mediator and take the training of being mediator. So in coming time, as the new law is in making, so when the justice, it is said that justice is sustained when it is immediate and it is cost effective. When we go for litigation, the litigation is always, is the litigation cost effective? Can anybody say that litigation is cost effective? Can anybody say that litigation is immediate? So I'm telling you from my hunch that in the coming time, the scene would change even in India in coming time. Within 2-3 years period of time, within 2-3 years, the Mediation Act will be implemented, and then most of the matters would go into pre-litigation mediation. The pre-litigation mediation can come as a precursor for litigation, adversarial litigation, even for arbitration or anything. The prescription could also be that there is a requirement of meeting the parties, and post that, if the disputes are not resolved, then in that case those would be referred to pre-litigation mediation, and that may become mandatory also. I had chat with several members of that committee, which has been appointed by the Supreme Court for framing that legislation. And then, of course, this is going to be an act of parliament later on. So why I'm saying this, I just wanted to say this so that I don't forget in the later part, that all the viewers, all the people who are listening to this communication, it is very important in today's time, wherever they can seek mediation training in today's time, and then supplement, there are various stages of those trainings. So go for those training. While you are sitting at home, it would be much important for you to prepare for that future which is coming in vogue, which will come. Why I say? Because several countries have already implemented them. In 2000, around 4 years back, Singapore conventions took place. Those have been adopted even by India.
Yes.
And post that, what has happened? In commercial disputes, in civil disputes, mediation is taking place as a pre-litigation process. And in commercial and in criminal matters, plea bargaining is taking place, which again India brought this plea bargaining long back in 2002, but at the same time we have failed to really implement it properly in the code of law. So this thing is going to come up in a significant manner and in significant volume. Why I say so, you must have heard, means there had been a lot of talk about force majeure in recent times. There have been millions of contracts which have been between tenants and landlords. There have been millions of contracts between the two parties, commercial entities. And all of them are affected by the COVID situation, which situation is not going to end any soon. It may take another 3 months or 6 months or a year. And once it settles and people have the money to go for litigation, they will come to lawyers. But by then, there is a possibility that this Mediation Act will come in place. So all that kind of thing which can culminate, means all those potential cases which may culminate into litigation in future and can benefit to number of lawyers, may just end within mediation bracket. So that's why I'm saying if you have the training of mediation, then you can definitely attract those kind of clients which can come tomorrow in your way, and then they would be more pleased to appoint you as their counsel if you have that mediation training. So that's just one idea that I wanted to say. So allow me a minute.
Sure. Meanwhile, you can send your questions in the chat box. We'll be receiving after sir is done.
So
Continue.
as we see, the old system had been adversarial to arbitration to mediation. Now the new system that will evolve is mediation to arbitration to adversarial to court system. So another very important thing which happened means which may come into this. What happens in today's mediation, if some of you have conducted mediations, that the mediation report means if the mediation is successful, then in that case the report contains that this has been successful, there has been an agreement between parties, that agreement goes to the court and the court puts a stamp over it, then it becomes enforceable by law. But what happens if the mediation fails? Then the only notation which contains is mediation failed. The mediation failed does not contain any reason why it failed, which party faulted, which party gave the reasonable offer, which party refused to accept the reasonability of the other party. All these factors are not mentioned in these reports today. But with the new legislation, there is a possibility that this may come, because it has been found that some parties at times give reasonable offer, other party just become unreasonable on the reasonable offer, due to which there is a litigation which takes more time, which takes more of court time, and at the same time it becomes cost. The cost effectiveness just go for a bounce. So in exercising those rights, the legislation may bring necessary embargo against a party which creates unnecessary hurdles in settling through mediation. So there is a possibility of that sort also, as I had been discussing with those people who are behind the legislation. So I just thought I will just point it out. Another phase that may be changing, which one should be aware and one should be ready for, that the government is going to change its strategy with regard to their litigation strategy. If you know that government is the biggest litigator in the country, central government is the biggest litigator, and then state-wise in the respective high courts, the state governments. With the Mediation Act coming into effect, there is a possibility that all this litigation will also be shelved. So why should you be prepared for that? So that means today there are thousands of lawyers who depend on the government brief. So if tomorrow those things are taken away from them and the government is not litigating too much and it's only mediation, so again that mediation training will come handy for you. Am I hearing something?
I think.
Hello? Somebody is asking something?
No, sir, you can carry on.
So I think it's already 6 o'clock. You want to put on questions?
Yes, we might put some of the questions if you want. Hello. Hello. So we might put some of the questions if you want.
You just asked the question. Means
Okay, sure.
It took.
Give me a second, sir.
That's 6:30. I have another.
Sir, can you throw some light on who is in the dominant position to settle the claim amount, who proposes settlement or the other party? That's actually a common question.
With regard to the mediation,
with regard to arbitration, I think.
No, arbitration, there is no settlement usually. Means although there have been settlement in the arbitration, but arbitration is essentially an exercise leading towards a decision. by the
In,
arbitrator or arbitrators. And despite
so
the
who is in the
proceeding
dominant
before,
position?
huh?
He's asking who is in the dominant position here, the one who will settle the amounts, or the one who proposes the settlement, or the other party. Because in
Okay, there is
mediation
no,
there
there
is
is,
a because in mediation there is a mutual settlement. If you go
right.
to a mediation, there is a mutual settlement. But in arbitration, one party go. I think one party go to the arbitrator for the settlement, and other parties they started the trial. Then.
No, usually what happens means, in my own experience, we had a big matter with ILFS. ILFS was our opposing party. I was for UP Power Corporation. So we had mutual claims. They had claims somewhere around 500 crore against us. We had claimed 1100 crore against them. So there had been settlement talks between, but arbitrators did not participate in that settlement talk. So while we were fighting in front of arbitrators, their fight led to Supreme Court also on several intervals, in High Court also in certain respects. But at the same time, because we had blacklisted, so that question came. Came before the High Court first, and then they came to Supreme Court. But while the arbitration was going on, arbitrators did not decide on settlement. They accepted the settlement later on once the settlement was done. So I was part of the settlement, means their counsel, me, their parties, our parties. We all sat together and worked out a settlement. So arbitrators means intentionally did not sit for that settlement. And once the settlement was done, then we placed that settlement with the arbitrators, and then the proceeding was concluded.
Okay.
So arbitrators do not sit on settlements.
Okay. Sir, another question is how Section 87 of ADR Amendment Act 2019 really impact ADR tech in dispute resolution?
Section
87.
87 has been quashed.
87 has been quashed in 2019.
Yes, by a recent judgment.
By recent judgments. The
Uh-huh.
last section 86.
87 has been quashed.
So, what can be called as a legal misconduct of an arbitrator?
Legal misconduct of arbitrator.
Yes.
Yeah, so this is a very important question, I must say, because in today's time, what happens means when the judges are appointed, retired judges usually appointed an arbitrator in a commercial matter, or any person who has been appointed as an arbitrator. So if he has an allegiance with the party, he had represented sometime that party in the past in some other matter, he had gainfully employed, or he had received monies for doing work for them earlier, he had been in their employment or anything, then in that case, today when the arbitrators are appointed, they have to grant a certificate. They have to give a certificate to the parties that they are not anyway related, and they would be impartial, they would be independent, and at the same time they are not related to any of the party, or none of their close relations are also related to the party or representative or their counsels. So that it is a format to that provided under the Arbitration Act. So as per that format, they have to give that kind of certificate to both the parties, all the parties who are involved in the arbitration. So it so happened in one of the matter, what had happened means I'll just not name the person who was involved. So it so happened in one of my arbitrations also. Interestingly, so when the arbitration the arbitrators were appointed, so opposite party appointed an arbitrator, and therefore the two parties appointed two arbitrators, then the umpire, the third arbitrator. So the opposite party had appointed an arbitrator who had represented party A, that is me, in some proceeding, some way. And he had been a retired judge. And then thereafter, his daughter was on the panel of that particular public corporation, even today. And she had represented somewhere in High Court in the similar matter arising out of the same cause of action. And despite that factor, this arbitrator continued. So therefore, I moved an application. And before any decision could have been taken, he himself resigned. So it so happened at times, so for removing the arbitrator, he should be impartial if there is any way that can be the prima facie established or talked about, that he can't be impartial for XYZ reasons, that he had been connected, related, or his relations have been connected, related directly, close relations, not some remote ones. Then in that case, the arbitrator can be removed or asked to step down.
Okay. Sir, Advocate Uday asked, can you please explain Section 9 of the Arbitration Act? Can you please throw some light on Section 9 of the Arbitration Act? Section 9 is, I think, interim measures by court.
Just
Sure, sir.
I'll read for him. It's a long section. Interim measures by court. What
you can give it-
what is? He may specify his question maybe, because it's a long section.
Mr. Uday, can you please specify the clauses?
A party
you
may,
ask?
before or during arbitral proceeding at any time after making of the arbitral award, before it is enforced in accordance with Section 36, apply to a court for appointment of a guardian, for interim measures. I think he must be asking for interim measures,
If you can
prevention,
give it,
securing the amount in dispute.
Sir, if you can give an overview, I think that would be good. You might get an idea.
Huh?
Or we can follow up with the next. We can follow up with the next question, sir. Can failing of mediation between husband and wife be taken on the board by the magistrate where the case is going on?
Taken on the board means one will have to be very, very specific. The failure of mediation and failure of mediation report will contain only mediation failed and nothing else as to whose conduct was what, except if suppose there had been extravening circumstances where mediator had to file an FIR against any of the parties because of their misbehavior or report to their about their conduct. Then in that case it can fall against party, but otherwise, yeah.
Isn't that a drawback in mediation? If we fail and there's no reason behind it mentioned in the mediation.
There is no reason mentioned behind it. Yeah, that's what I said. It means is a party who acts reasonably and the other party acts unreasonably constantly, and mediation fails because of that. So the cost has to be put, and in the coming new act, which is being drafted, possibly there is going to be a provision for this. Because at times what happens, suppose there had been a recovery suit which has been filed, or there have been 138 section 138 matter which had been filed, and the matter came before Supreme Court. Suppose the party had to recover 1.5 crore and the other party in the mediation proceeding offered a property of 1 crore rupees. The party who has to take that money says no, I can't, or a property worth 1.5 crore equivalent to, he does not have money but he is offering his property. So in such a matter, whether it will be said that this is a reasonable offer or not. So ordinary prudence will allow you to understand that this is a reasonable offer, that the party cannot, means sometimes what happens, the house property is not immediately sold. So either the other party has to wait till the time house is sold, or may accept the house itself. Value by way of means government appointed valuer, you can verify the property. So sometimes it so happens that party act irrationally, and that is not reflected in the mediation report. So that is a requirement which should be there, that the party which has acted reasonably should get advantage to some extent when the litigation is getting finally decided by the court in case of mediation failure.
Sir, a gentleman is asking.
Now, right.
Can I continue? Sir, a gentleman is asking, but if in arbitration clauses, arbitration clause seat is in Mumbai party, but parties consented for proceedings to be conducted in Delhi. So now where would be award passed, that is in Delhi or Mumbai, and award where can be challenged?
As I told you earlier, parties may decide on change of seat. the seat would be as contained in the agreement itself. Party is by way of conscience, means by way of consent, may decide the change of that seat, but then that has to be reflected in their agreement in writing. If it is not so, then at best it would be a venue in Delhi, but the seat would be of Bombay only.
Okay. So, but the jurisdiction will be in Delhi because they have consented it to be in Delhi.
If they have consented, then in that case the seat would be changed to the Delhi.
Okay, sir. So next question is, if we may, can challenge in this of the decision of mediation can be challenged in this pandemic?
Decision of mediation. See, mediation is not a court proceeding. Mediation is not something which has a court authority of a legislation, a statute. Mediations are usually either court-appointed mediations which fail or pass. And once once an agreement has been arrived at in a mediation, then in that case it cannot be challenged by any party, because you have acquiescence yourself to that particular agreement. Then in that case you cannot, unless it has been shown by you that it has been forced on you, or you were in the unsound mind at that point in time, and you were inebriated, you were not able to think properly, which is very unlikely to prove, you know.
So we might wrap the session up with this. Thank you, sir, for your valuable address, all those valuable insights and to the esteemed speakers. I move over the mic to my co-host Megha Dixit.
Good evening, sir. It's time to sum up the session. My warm regards to our speakers, Advocate Nakul Devan sir and Advocate Vivek Narayan Sharma sir. I would also like to thank our media partners, Virtual Lawyer, Bhrashtachar Virodhi Morcha, Kacheri.in, Nation India, BHPC News, NALC India. I would extend my thanks to our preferred partner, lawupdates.in. Last but not the least, no such event is successful without a patient audience. So I would like to thank all the attendees of the webinar. Certificate for the webinar will be issued within 2 days. Thank you everyone and have a good day. Thank you.
Best wishes to all.
Thank you very much, sir.
If you have if any one of you may have any query, you may write directly to me at viveknarayansharma@gmail.com. So I would be able to address it.
Surely, sir.
The short time they had been, means the subject is very wide, means it was very difficult to confine those different things into this 40 minutes time period. But at the same time, I just tried to think of the new thing that is coming along, because we all have seen Arbitration Act. We have a lot of time seen the Arbitration Act, but nobody has seen really what is the conciliation. Nobody has really known what exactly the mediation is and how the change scenario would be in future. So I just thought that I would I will make you aware about those new facts which are coming in, which are going to be in effect very soon. So my best wishes to all of you. Thank you.
Thank you so much, sir.
Thank you so much, sir.
All of you. Bye and take care. Take care, very good care of yourself, because it is very important in today's time that you are unaffected by the COVID.
Thank you, sir.
Okay.
Be safe.
Thanks. Bye all.
Thank you, sir.